Good afternoon, everyone. It's Aaqib Javed here, one of the presenters for today's seminar. We're waiting on some other people to join, so we will start in about 3 or 4 minutes' time. So I'll just turn my camera off and then you'll see me again in a few moments. Thank you.
Good afternoon, everyone. I think we'll make a start now. I think most people have joined. Just to introduce myself, I'm Francesca Massarella, one of the presenters this evening. I specialise in family law. I do both public law and private law, and that includes lots of fact finds. I know that all of you tonight, or most of you tonight, will be the people on the ground that are the ones in charge of preparing for these fact finds, and so what Aaqib and I have intended to do is just to try and make that process easier, and just to give you some sort of tips and tricks from what, from our perspective, would make that process smoother and better for the client.
Thanks, Francesca. I'm also a family law practitioner, both public and private law. And like Francesca, our workload involves fact-find hearings on a regular basis. And those can be quite small and concise in terms of allegations raised, and others can be quite vast, and there's all sorts in between as well. So hopefully this session will help assist when it comes to preparing for fact finds. I'll just start the PowerPoint now. Hopefully this works. Right, I'm going to presume that everything is fine. And I'm going to make a start. So in terms of today's agenda, It's a fairly short agenda, but hopefully one that will cover lots of ground. So firstly, we'll be looking at some developments in the law which informs how fact finds proceed. And then we'll look more generally in terms of how to best prepare for a fact find, and then also conversely how not to prepare for a finding of fact hearing. And then there will be time for some questions and hopefully answers as well.
So where we thought we'd begin tonight is to start by talking about why fact-finding hearings are directed at all. I think there are lots of different competing reasons for why fact finds are required and are helpful. But the paramount consideration, as I'm sure everyone watching will know, is that it's about working out what factual matrix is required for the court to make decisions about the child's welfare. Ultimately, there are other benefits to fact-finding hearings in ensuring that parties feel that they've had their voice heard and that the court's made a determination about disputes and issues between them. But the primary focus is always on the welfare of the child and what's necessary for the court to determine in order to make wider decisions about that welfare. It's also an opportunity for victims in domestic abuse to have a voice in instances where they might not. Of course, there's a difference in between the family court and the criminal court and the standard of proof, and something that would be litigated upon in the family court may never make it to a criminal court. And so that's a very important part of fact finds, is allowing for that opportunity for things to be litigated in a situation where they might not be elsewhere. And certainly that's very important for not only the client often, but also for the child, because it gives an opportunity for determinations to be made, which are very important to the judge then going on to make wider welfare decisions. And so certainly that's the starting point, really, is to consider why fact finds are required, because that leads on to how you prepare for them and what the focuses need to be.
Thanks, Francesca. I should have mentioned we do have our senior clerk, Lee, in the seminar. If there are any issues, just flag them up and they can be dealt with. So turning then to the law, and of course no fact find or discussion around fact finds is complete without looking at the legal principles behind those types of hearings. And the case of H&N, which I'm sure that most of you will know well by now, still forms the bedrock in terms of the principles that must be applied or considered when dealing with finding of fact hearings. So looking then at what that case has shown us, you'll know that Practice Direction 12J remains good, that H&N didn't change that practice direction in any substantial way, and that should remain the guiding principle when preparing for fact finds, and that's both when you are preparing in terms of making allegations and also responding to allegations. And importantly, although H&N was quite wide-ranging and it covered lots of different issues that arose, one of the more important, I think, principles that it establishes is that the comments in F&M from Mr. Justice Hayden were endorsed by the court, and essentially what that does, and I'll just read out the paragraph which has discussed F&M. So this court in H&N states that in the family court, that expression, i.e. that of controlling and coercive behaviour, is given no legal definition. In my judgment, it requires none. The term is unambiguous and needs no embellishment. Understanding the scope and ambit of the behaviour, however, requires a recognition that coercion will usually involve a pattern of acts encompassing, for example, assault, intimidation, humiliation, and threats. And then Mr. Justice Hayden went on in F&M to say, controlling behaviour really involves a range of acts designed to render an individual subordinate and to corrode their sense of personal autonomy. Key to both behaviours, as that's controlling and coercive behaviour, is an appreciation of a pattern or a series of acts the impact, and that's important, the impact of which must be assessed cumulatively and rarely in isolation. So those words from Mr. Justice Hayden were endorsed by the Court of Appeal in H&N, and combined with Practice Direction 12J, give a clear indication as to how the court will approach the issues of domestic abuse and also controlling and coercive behaviour. Paragraph 37 then of H&N also deals with whether or not we need a fact find. Certainly in recent years, there has been a tendency to list fact finds, and my personal experience, and it is just that, my personal experience is that in more recent times, i.e. over the last 6 to 12 months, the courts are taking a more robust approach when it comes to dealing with finding of fact hearings. But the principles as set out at paragraph 37 of H&N remain good in my view, and there is a checklist, and I won't go through the entire apologies. I won't go through every single aspect of that checklist, but it's important to note that in H&N it was stressed that the allegations must be relevant when deciding whether to make a child arrangements order, and if so, in what terms. And in my view, what that indicates is that sometimes, even if there are some allegations, if it doesn't ultimately impact upon the order that's being sought, then the court may not deem it to be necessary for those allegations to be pursued. Secondly, the purpose of a finding of fact hearing. Francesca has already touched upon the fact that sometimes allegations which are raised in family courts are not then pursued in criminal courts. That has to be viewed through the lens of the child's welfare. So simply having that as a potential issue, i.e. that a victim may not feel that they have been heard, or that their voice has been properly recognised by the court, that may in itself not be enough to warrant a fact find in family courts. There has to be a purpose which must be driven by the child's welfare. But perhaps the aspect or the issue which was highlighted by the judges in H&N, which makes it more attractive often to have fact finds, is the importance to establish a factual basis. But of course, the counter argument to that is that often the factual basis will already have been established through different courts, tribunals. There might be a wealth of evidence to suggest that a course of action has been taking place, and even if it's the case that there's not enough evidence to show that another court has found that certain behaviour has or has not happened, sometimes it does then focus the minds of the parties, because the parties can then respond accordingly. And of course, when advising clients, both strengths and weaknesses of cases must be looked at. And if the case is particularly weak, for example, and if there are other third-party reports or assessments which detail some of these allegations, then appropriate advice would need to be given. And fundamentally, the judges in H&N endorsed Practice Direction 12J, which is all about the test of necessity and proportionality. And so H&N, in my view, hasn't changed anything. What it has done is given a very concise and focused checklist, which is useful when looking at whether or not fact finds are needed. But there are things that we need to be aware of. So, for example, I have had cases, and in my experience, certain judges are more alive to this issue than others, where, for example, contact is going ahead, and that might even be going ahead on an unsupervised basis. And I've had judges turn around and say, well, Mr. Javed, why does your client want to pursue a finding of fact hearing when the reality is that this child has been having contact on an unsupervised basis for however many months? There are, of course, ways to respond to those kind of judicial questions. and those responses will depend on the facts of any given case, but that is something that you must be alive to. If contact is going ahead, especially if it's unsupervised, the court may take a dim view when it looks at whether or not a finding of fact hearing is actually needed.
Thank you, Aaqib. And so certainly one of the things that you need to be alive to, even in determining whether or not there needs to be a fact find, is making sure that the Scott schedule filed and the way that the case is pleaded is done in a way that helps your case even before the decision of whether there's going to be a fact find has been made. There has been a recent suggestion by the courts that Scott schedules are no longer fit for purpose, but in my experience recently, this hasn't stopped the court directing a schedule of allegations to be filed of some sort, whether that looks like a Scott schedule or looks like something else. It's certainly the court wants to see a schedule of what somebody's alleging before they make a decision about whether or not there is to be a fact find at all. And that's a very important part of the preparation, because that's going to be key to the case before you even get started. There is a different schools of thought on how a Scott schedule or a schedule of allegations should be drafted. Some feel that there should be a focus on a pattern of behaviour, and others on specific incidents. Ultimately, it needs to be something that's decided on a case-by-case basis and what is most appropriate in those circumstances. If it is a case such as that, like F&M, and it's a pattern of coercive control, then a pattern of behaviour is something that's really important to highlight within a schedule. If the focus is more on physical abuse, for example, then it may be that specific incidents are what needs to be focused on. And in doing that, there also has to be a consideration of the timing of those incidents. For example, is it something that happened 10 years previously, or is it something that happened in the last 6 months? There needs to be a very careful balance when pleading the client's case of what goes in that schedule and what doesn't, because what you don't want to do is risk having something there that draws away from the salience of the client's case because it's something that happened 10 years ago and is now irrelevant. Scott schedules need to be focused, and those allegations need to be the ones which are relevant for the court to determine. And that ultimately makes a massive difference, certainly in my experience, when trying to argue for a fact find, if the allegations are relevant and are things that the judge can look at as being reasonably in need of determination. There has been quite a lot of recent case law on the issue and things to be alive to. In terms of the way that the court will approach any findings, it's important to note that the court isn't bound by the cases put forward by the parties in any event. And that was made quite clear in the recent case of RIA number 2, children findings of fact in 2019. Ultimately, the court can make findings of its own, and that's something that needs to be thought of when drafting a schedule. The perfect example of this is a case I had recently where the allegation pleaded was that the father had punched a door. In his oral evidence, he denied punching a door, but did volunteer that he had instead punched a wall. And unsurprisingly, the judge made a finding that he had punched a wall because that is exactly what he had admitted. And so it sometimes doesn't matter quite exactly what's pleaded, because the court may come to a different conclusion on its own in any event. It's also important to remember that the court's primary focus is fairness, and that comes from the recent case of Re S, a child, 2015. And again, in the case of Re G and B, fact-finding hearing 2009, again, it was highlighted that judges can adopt alternative solutions independent of the parties' positions and make entirely different findings if appropriate. However, having said that, when the judge does make a different type of finding to that which is sought, they've got to be cautious about this. And it's very important that if that's done, that the person who the allegation the finding is made against has had the opportunity to respond to that. In the example I gave a moment ago, my client had that put to him fairly in cross-examination, just to double check that exactly was what he'd said, that he had indeed punched a wall on the date that he was alleged to have punched a door. and he confirmed that that was the case, and so he'd had proper opportunity for that allegation to be put to him, and therefore it was perfectly right for the judge to come to the conclusion that he did. He had compelling reasons to do that, and those findings were fair and consistent with natural justice, which is the test that the judge would need to satisfy. So to summarise, in respect of Scott schedules and pleading a case, the primary focus is focusing on the relevance of the findings that you are pursuing, to make sure that those are the best findings of your client's case and that they make the points that you want it to make. The court is not bound by the parties' arguments, but the focus has to be on fairness, and judges do have discretion to consider alternative solutions. And so when pleading something, if it needs to be specific, then that has to be borne in mind, that you may have a specific allegation pleaded, but the judge may make a different specific finding. Certainly, though, the court does have to have caution when doing so. Overall, what I'd stress in terms of pleading the case is making sure that this is where the preparation is most thorough, because, as I say, that's the important thing for the judge to see when making a decision about having a fact find at all.
The case of K&K, which I'm sure that many of you will be familiar with. There has been some discussion about K&K and whether or not that has rowed back the approach that had seemingly been taken by courts in respect of domestic abuse allegations. K&K does stress the need to have a proportionate approach towards finding of fact hearings. The paragraphs which are set out in the PowerPoint really do show exactly what the court's view was when it comes to focusing on the allegations. And paragraph 70, for example, which is cited in this PowerPoint, you'll see that the court said in K&K, the court only decides individual factual allegations where it is strictly necessary to do so, in addition to determining the wider issue of coercive or controlling behaviour. So that's a very high threshold to meet, strictly necessary. And in many ways, what that does is heighten the need for the court, before a fact find is even listed, to take a view as to how proportionate it is to actually have a finding of fact, and indeed what allegations should be pursued. And there does seem to be a distinction now between more general coercive or controlling behaviour type allegations and specific incidents. We then have at paragraph 85 the danger as highlighted by the judges in K&K, where the subtle findings are then somehow missed because there's a general or broad brush approach taken towards domestic abuse. There's an example of that very recently in my own case, where the father in that case was alleged to have strangled the mother, and although it was pleaded by my client as the father has strangled me, and of course, as many of you will know, that the Domestic Abuse Act of 2021 has defined strangulation, and I invited the judge to accept that the action that was alleged was indeed strangulation on the part of the father. The court was very hesitant to label it as strangulation, and instead made a very specific finding, which I think, well, from memory, was that the father placed both hands on the mother's throat and temporarily restricted her breathing, or something of that nature. It was very precise as to what finding was made by the judge, and clearly, if one was to read between the lines, the judge was thinking very carefully about what had been established in K&K and how a broad brush approach wouldn't do. So simply saying that the father strangled the mother without necessarily identifying how it happened, for how long it happened, may not properly reflect on the finding made. So the court needs to be alive to that particular issue as well, and that sometimes means that findings which were pleaded one way are then found to have happened in a slightly different way. And I certainly came out of that hearing slightly puzzled, because I thought that the Domestic Abuse Act had made it very clear that that particular action was indeed strangulation. But of course, when looking at K&K, there is an argument to be made that the judge was perfectly entitled to specify exactly what that action was, rather than label it. And of course, you all know that family courts are very hesitant in adopting criminal concepts, even if those issues are raised in finding of fact hearings. So family courts, when they make findings, even though they may appear to qualify as a criminal act, the family courts might not actually make a finding that that particular course of action was indeed criminal. It's very complicated, and there has been recent case law dealing with that issue, and that's probably, or perhaps, something that could be discussed at a later date.
So the key for finding of fact hearings are that there is very thorough preparation in advance, and it really is about that preparation being done from the off. That means from the very first conference with the client, making sure that everything is really clear about their case and knowing exactly what they're saying from the outset. That's sometimes easier than other opportunities. It depends on how a application is listed, whether it's for a child arrangements order, for example, where there's a very structured federal hearing set up, or whether it's something done urgently because there needs to be a prohibited steps order or a specific issue order for a return. That's something that can't always be done in those circumstances, because that first statement needs to be done so quickly that there isn't sufficient time to consider everything in detail. But when there is time to do that, it's really important that it happens. Going through very carefully with the client exactly what allegations are being made is really, really important. And with each of those allegations, it's important to explore what professionals have been involved. Had there been a referral to social care? Did they report this to the police? All of those things need to be noted as you go through each allegation, so that that evidence can start to form its own life before we even get to the realms of having a witness statement directed. It's much, much easier to prepare those statements and take instructions for a statement when you've already got the salient points that the client will want in that witness statement and a clear idea of what kind of allegations they are pleading and making. It's also important to ask whether or not these allegations have indeed been tried in any other court. So again, that brings it back to the point of the criminal courts. It may be that the client says that their ex-partner assaulted them 2 years ago, and it may be that that person received a conviction for that crime in the criminal court. If that's happened, and that's something that the family court may or may not need to determine, 9 times out of 10 they will not, because that's something that can be an agreed fact. It's not something which the court then needs to litigate on again, and certainly wouldn't do unless in very specific circumstances. So it's all of those questions which appear to be things that perhaps you would ask later on that are best done right at the outset of the case, so that you can begin to build that picture of evidence before you even get into court. That makes the process smoother, not only for the client but also for you, because there's a very clear idea of what's required in terms of disclosure from the court as well.
You may have heard or seen that Lord Justice Peter Jackson in WA last year essentially ruled that foreign findings of criminal activity, or convictions rather, would be permissible, at least admissible, in family court proceedings in this jurisdiction. So it's important that even if there are convictions from a foreign court, that is stressed, and the court is made aware of that, because ultimately those may well go towards issues around the child's welfare. So looking at best practice, or how we think cases should be prepared, we need to focus on disclosure, and that is disclosure of evidence. There needs to be a real focus on where that evidence is stored, who the author is of that evidence, and avoiding delay is crucial for a number of reasons, but perhaps two of the more important reasons is that if the court at an early stage is made aware of the evidence that has been recorded, that may persuade the court to list for a finding of fact hearing, and secondly, it allows you and your client to be able to prepare as best as possible. What is always unhelpful is when months down the line, after a number of witness statements have been filed, a third-party report from the local authority is received, which completely undermines your client's case. Clearly, that isn't going to help anyone. It won't necessarily even help the court, because that just invites further delay, further statements. And so do consider where information may have been stored, who it may have been recorded by. And then, of course, it may be that there are specific third parties, including public bodies, which may have information. So if there has been police involvement, then Annex H orders should be applied for at the earliest opportunity. I appreciate that quite often the first hearing is usually done on an urgent basis, and there may well be a directions hearing thereafter. It's important that the relevant applications are made as soon as possible. And also, it may help if a proportionate view is taken towards those applications being made for disclosure. So, for example, if you are applying for an Annex H disclosure in respect of police, then are you asking the court to endorse an application in respect of a specific time period? Because in my experience, courts can often be more amenable towards authorising or endorsing such an order if it is fairly limited. I think courts are well aware, and judges are well aware, of the pressures that the police force faces when it receives disclosure requests. So anything that can help move things along will be useful. Looking at other forms of evidence, and I appreciate that much of this will be known by many, but it's always important to think about social work involvement. In my experience, there is more often than not pre-existing social work involvement with parties that come to court, even in a private law setting. And it might not be simply the case of obtaining formal minutes or assessments. There might have been family group conferences, there might have been discussions with the school that the social workers recorded. All of those pieces of information will be useful. And thinking about school CPOMS records quite often are crucial. I've had cases where the strength of allegations has been made on the back of the CPOMS records. Those are vital documents, and if and in my view, a question should always be asked to clients whether or not they have discussed the issue with schools, because of course the most vulnerable clients, their only access or their most readily available access to any person outside of the family home might be the school. So that's very important. There are other forms of disclosure or potential pieces of evidence that could be obtained by disclosure. I have had a case before where notes from the children's counselling sessions have been obtained, but that is a fairly slippery slope, because there is the counter argument that could be made that an over-reliance of what the children have said is a sign of parental alienation, because essentially the children have been primed to make allegations. So that's something that the client will need to have explained quite carefully, because on one hand, yes, throw everything in because it might support their case, but my experience has been that counselling usually takes place after the perpetrator or the alleged perpetrator leaves the family home, and if that happens, then there is a certain degree of exposure against allegations of parental alienation. and there will of course be cost implications for third-party disclosure, most commonly perhaps when looking at police disclosure. It may be the case that your client is publicly funded, especially if that client is making allegations, and in that case the legal aid agency ought to be covering the costs of that disclosure. But if the other side is not publicly funded, or is representing themselves or privately even, the implications of such applications need to be explained, and so they aren't caught on the back foot when it comes to the hearing in which these applications are pursued. And of course you'll know that the court may well do a means analysis at that hearing to make sure that the issues around funding are sorted before disclosure is obtained, and that's vital, because what we don't want is for orders to be made and then invoices not to be paid, because that will just lead to more and more delay, which cannot be good for a child.
In terms of the preparation, it's not just about the evidence, but it's also about the client. And of course, I know that all of you will be very familiar with doing this, but managing the client's expectations is such a vital part of preparing for these sorts of hearings. The client needs to completely understand the process so far as they're able to, and particularly in terms of stressing the role and the focus of a finding of fact hearing. It is not simply about them having their say and their day in court, whether that's the person making the allegations or the person disputing them, but the focus is about the court making decisions about the child. And that's something that very much needs to be stressed to the client from the off. They need to understand that the decisions that the court makes in terms of fact finding are primarily focused on the welfare of the child and the ultimate decisions. And it's not simply that one parent will be punished if they're found to have done something that the other alleges. Of course, the court will look dimly on poor behaviour, but ultimately that's not going to be, the consequence isn't going to be for the person who the finding is made against, but the consequences about the child, and certainly the contact that that child has going forward, or who that child lives with. And that has got to be the focus in the forefront of the client's mind throughout the case. And I appreciate that sometimes that's very difficult to stress to some clients, and that might not be a message that they take easily. On the back of that, it's also important to very much discuss the strengths and weaknesses of the client's case with them from very, very early on. Point out the potential problems with some of the allegations that they've made. For example, a very common one is that someone will make a very serious allegation of something that's happened, but then talk about how they've allowed unsupervised contact between the child and that parent for a period of time afterwards. It has to be accepted by the court, it very much is, that victims of domestic abuse may find it very difficult to stand up to their abuser and make decisions that they don't like. But that's something that the client needs to be alive to, as something that the court will consider when looking at their evidence as well, and considering whether they acted in the appropriate way for the child and kept that child safe. And there can sometimes be a fine balance within those sorts of things. It's also important to stress the importance of knowing that the judge can make different findings. And certainly if someone is making an allegation which is so ridiculous and not supported by any evidence whatsoever, there is a risk that the court may make a finding that that person has lied when they're giving their evidence, and lied when making that allegation. And so that's something that the clients need to be very much aware of throughout the case. And if there is an allegation that you feel as a professional is something that isn't supported by the evidence, then it's important to highlight that and to make sure that the client understands why. The way that I would always approach it with a client is that it's not saying that I don't believe you, or that I don't think this has happened, and I'm not suggesting that's the case. Nobody is, but you have to understand that it's how the court looks at the evidence, and it's not always about who's believed, but it's about whose evidence supports that allegation. That's something very simple, but it's quite often something that clients find difficult to hear, particularly when it's a conversation that you're having at the pre-trial review or even during the fact find. So the earlier those conversations can happen, the better. There will, of course, be clients that, regardless of anyone's advice, want to pursue those allegations and don't accept what they're being told. But it's very helpful, particularly to counsel, if that advice has been given by the solicitor before we come into the picture at all, so that everybody is on the same page and they're hearing that advice several times over. And that's incredibly important as well, to stress the kind of thing that they will face in court, and to tell them how to expect in respect of cross-examination by somebody. And certainly, again, if someone has a very weak allegation supported by no evidence, the client needs to be under no illusions that that's something that the other side will pick upon in cross-examination, that they have to be prepared for. And that's one of the most important parts of the preparation, in my view, is over and above all of the evidence gathering and making sure the paperwork's in order. Ultimately, the real test is when the client goes in the witness box, and they need to be prepared for everything that's coming to them, and that needs to happen from the very first time that you meet.
On that point, Francesca, I recall a case that I did a few months ago now, where at the end of the finding of fact hearing, my client, who was the father, had a really damning judgment made against him, but he was caring for the children full time, and when it came to the welfare stage, the children stayed with him because there were some real weaknesses in the mother's ability to protect the children, to care for the children, to well, there were a host of issues in her ability to care, and that's rare, but it does go to show that often, even with negative findings, clients can still receive fairly positive outcomes at the end of proceedings. And so there is that balancing exercise where, yes, on one hand you might have a strong case, but it might not end up with giving you with what you want. And similarly, at the finding of fact case stage, a client might have a weak case, but that isn't the end of the story, because it may be that the welfare analysis actually isn't impacted massively by the findings, because of course there might be weaknesses in the other parent's ability to care for the child. These things are fact by fact, or they are dealt with on a fact by fact basis. There's no one rule fits all policy, but those types of conversations need to be had with clients, because ultimately they need to be aware that the whole process will have its ups and downs, will have its strengths and weaknesses. Ultimately, the finding of fact hearing informs the judge in terms of what the welfare analysis could be, but it does not dictate it, and that's something that should be borne in mind. And then looking at this next slide, then, in terms of identifying witnesses, finding of fact hearings involve witness testimony, that goes without saying, but you'll need to consider at a very early stage, and this can quite often be difficult, especially if clients have never spoken about their abuse or their alleged abuse before, but you will need to ask questions as to if it was witnessed, who it was witnessed by, those types of probing questions. And at an early stage, you'll need to persuade the court that additional witness statements are needed in order to establish your client's case. Just importantly, and on that point, I've had cases before where, even though a judge might have allowed a statement, they then don't allow oral evidence from that particular witness. It's rare, but it can happen, and ultimately it's up to the judge to allow or to permit oral evidence given by any particular witness, depending on whether the judge feels that it's needed. But going back to witnesses, then identify the relevant witnesses early on, prepare their statements. My experience has been that third-party witnesses, i.e. witnesses that aren't parties themselves, usually only get the one witness statement filed, and to make sure that that's comprehensive, it contains all of their testimony. And I always find that it's helpful, of course it depends on what the witness has to say, but I find that it's helpful if witnesses are very frank, if they have heard things from one of the parties, and that's made very clear. And of course, courts might not always grant permission to family members as witnesses, because it may well be that they are relaying what's been told to them rather than what they've seen. But of course, if they have seen incidents, then that's of real value, and in any statement it should specify exactly what they have seen, when it happened. I always find that a witness is really persuasive if and when they're able to demonstrate the aftermath of the incident. Do they have to ring for an ambulance or police, for example? All of that is very persuasive. But as Francesca mentioned earlier, you can put anything in the witness statement. The true test is when that witness gets into the witness box, and on that, any witness, well, any party and witness should be told to reread their statement, so when it comes to giving their evidence, they are prepared and they can recall what they have said. Always think about whether or not you need a professional witness, i.e. does someone from the school need to attend to give evidence? Does a social worker need to attend? All of these things need to be considered. In private law fact finds, that's generally not the case. And I've not had a case yet where a social worker has given evidence in respect of a fact find or allegations being pursued in a private law context, but it's something that you should consider. Always ensure that the court does list for a pre-trial review. Those can really make or break a case. If there are issues that can be resolved at the PTR stage, then those can assist in ensuring that the finding of fact hearing remains on track. And it's very similar. I mean, if any of you do public law work, you'll know that the PTR stage is called the IRH stage, and the case plan or a witness template is needed at that stage. It's the exact same for a private law hearing. And there is also the issue that needs to be considered in respect of re-W applications. Do children need to give evidence in a private law hearing? I've certainly had cases where judges have been very keen to hear from children because a child might be Gillick competent, for example, and even if they weren't, there is no bar on being able to give evidence. But courts can often want to hear the parties' views in respect of children giving evidence, and that's something that should be considered very carefully, especially if a client places lots of weight on what they've been told by a child. That's very important, and it's important that the party, that your client is aware that their children might well need to give evidence if the court feels that that is something that is needed. But at the same time, it should be stressed that is quite rare, and I would hate to discourage any lay client not to pursue an allegation because they feel that their child will be cross-examined, and that shouldn't be the thing that stops someone from pursuing an allegation, but it is something that needs to be raised. Similarly, expert evidence in the context of private law. At a fact-find stage, it's probably not going to be an issue that arises in most cases, but I can certainly see in specific incidents that they may well need to be experts coming in to give evidence. For example, there might be doctored images, there might be cell phone or rather phone analysis needed. Things like that may actually warrant an expert having to give evidence at the finding of fact stage. The key question, as you all know, is does the court allow questioning of an expert? And if an expert's report goes against your client's case, certainly you'll be wanting to make the argument that an expert should be cross-examined, and of course you'll need to be able to justify that particular argument. Also, very importantly, it does not follow that because there are special measures in place for the alleged victim of domestic abuse, that those measures are then put in place for his or her witnesses. I've certainly had cases in the past where judges have not allowed special measures to be put in place in respect of witnesses because simply the court feels that either an application has not been made and it should have been made, or that there are no grounds for such an approach being taken. And please ensure that your witnesses understand this. And if there is the need to make an application, that application is made in a timely fashion.
It's also really important when looking at the witnesses that you need in terms of how you then draft those witness statements, both for your client and for any other witnesses that are required. As we discussed earlier, the initial schedule of allegations is the most important document that will be in the bundle, as are the very first statements of both parties, and of course the response to that schedule. That initial statement is what will be referred back to throughout the proceedings and throughout the fact-finding hearing. It's really, really important there's as much detail in that as possible, because of course if a further statement is filed requesting more detail, that then leads to questions such as, well, if this is a detail, why was that not in your first statement? And that's an obvious then cross-examination point if that's not being covered from the off. The same applies in respect of if there do need to be any additional statements about anything, referring back to that very first statement to make sure that there aren't any inconsistencies, or if there are inconsistencies, that those are addressed and then mitigated. Some of the worst evidence that comes out from lay clients is when they are questioned on something that's inconsistent, and they give an even more inconsistent answer about why it is. There may be a perfectly good reason for that. They may have misunderstood an initial question that was asked for their first statement. They may have remembered something differently, and quite often an obvious or innocent explanation can be given as to why there is an inconsistency. But if that isn't addressed until oral evidence, then that gives the court is very much open then to looking at the credibility of that person and whether or not that evidence is inconsistent because it's not the truth, or whether it's inconsistent because of another reason. If there's another reason and that's already been highlighted in the statement, then you've already mitigated that line of cross-examination before it's even begun. In respect of any exhibits that are going to be attached to the witness statement, these need to be proportionate. Quite often, I appreciate that lay clients will have hundreds of pictures at very different angles that they feel are all incredibly important for the court to see. They're not, and we know they're not, but it's important to stress that to the client from the off as well, and make sure that what's attached to that statement is relevant to the issues in hand. There is also a tendency, particularly when there have been allegations of domestic abuse that involve the children, that a client will want pictures of the child with them smiling and happy. Those pictures quite often never make a difference. The court simply will make a determination upon that and not place any weight on those pictures, because parents aren't going to take pictures of the child when they're screaming and crying and include those as exhibits. All of those pictures will be smiling and happy. And so it's those sorts of things that need to be carefully thought about when exhibiting things to a statement, to make sure that the things that are exhibited are things that will help your client's case and aren't muddied by lots of irrelevant things that are alongside it, because quite often the most relevant documents might not appear so until you look into the finer detail. The same applies in respect of if there are going to be any media exhibits. These need to be relevant, they need to be accessible to the court, and they also need to be limited, particularly in cases where there is a different language involved other than English and interpretation is required. If there's going to be any kind of media that needs translation, there's often a very high cost involved, and it's a high cost which you're going to have to try and satisfy the legal aid agency is necessary. And so those are things that need to be addressed with the client early on, particularly if they're not in receipt of legal aid, to work out whether or not the media exhibits that they want to attach are relevant, and if all of it's relevant or if only a certain part is relevant. And again, that's where the preparation comes in, because if all of these questions are had early on, they're things that can be addressed early on and rather than being done at last minute.
I appreciate that we are coming up to 5 o'clock. I hope that you'll be able to stay with us, because there are a few more slides to go, and then hopefully the opportunity to ask questions as well. So it'd be really great if you could stay beyond 5 o'clock, because I think we will be pushing past that point in any event. So looking at preparing a client for a finding of fact hearing. We've already discussed this, but be realistic. It's so important that clients understand that not all forms of bad behavior go towards risk towards a child. And essentially that's what the court is looking for. What risks are identified or established which would impact upon the welfare of the child. I've certainly had cases where clients want to pursue things such as one particular the other parent being away for work, and although that may have been a feature of that relationship, how that goes towards risk, it's still unclear to me. And in any event, things like that can be addressed sensibly through discussion. And then also looking at the issue of concessions. If your client is facing allegations, rather than going through a multi-day finding of fact hearing, is the client better off making sensible concessions? Is that proportionate? That's something that's going to be more appetizing in my experience if there are cross allegations. I think that gives an incentive to either party or both parties to then concede sensibly. But that's something that can also be considered at a fairly early stage, especially when both parties are responding and also then making allegations. Looking then at the issue of court time, there does need to be a realistic approach towards issues and balancing that against the availability of court time and space. This, in my view, is a double-edged sword, because I've had cases where courts have listed matters for, say, 3 days because there are 6 allegations, thinking that that could be resolved within those 3 days, and ultimately you then need twice that because it turns out that there are lots more or a lot more issues that come out during the finding of fact hearing. It's very difficult to accurately estimate just how long will be needed for a finding of fact hearing, and in my view, the amount of allegations don't always correspond with how long you need. So you'll need to think very carefully, and indeed if you are instructing counsel, counsel will need to think very carefully about how much time is being asked for at the finding of fact hearing stage. But immediately there is that tension that comes to mind, because if in K and K the court wanted these issues to be resolved promptly and without delay, and if there was the need for a finding of fact hearing to be listed sooner rather than later, well, the immediate obvious issue there is that you might not have all of the disclosure at the time of the finding of fact hearing being listed. How then do you balance the need to consider what evidence might arise against the need to properly think about and invite the court to list for a finding of fact hearing for X amount of days? That's something that has no real answer, and there is that tension between listing sooner rather than later.
One of the other things to consider is that if you're going to brief counsel, when should you do it? The usual stage for counsel to become involved is at the pre-trial review or the finding of fact. Certainly from our perspective, it's so much easier if we are instructed at the pre-trial review, so that we can have an input on the case plan, the witness templates, any time estimate, and to identify any other issues at that stage that need to be sorted out ahead of a finding of fact. It's also very useful for a conference to be arranged before the pre-trial review, so that the client can meet counsel and understand how the process is going to work thereafter, to add to what you as solicitors have already told them in terms of preparation. That's incredibly important, so that they can get a feel for the kind of advocate you are, and also to explain how everything's going to work, and to talk through the potential strengths and weaknesses of the case with them again at that stage. To that end, it's incredibly helpful to counsel if there is a really thorough brief and chronology given before that conference. It's sometimes very helpful for you on the ground to explain what's gone before and why, because sometimes an order doesn't tell the full story. if a particular statement has been directed and there's a particular reason for that that perhaps isn't obvious, knowing those sorts of things before going into the conference with a client is incredibly helpful and important. In the same way, if particular advice has been given to the client, i.e. your case does have quite a few weaknesses and these are why, these are them and this is why, then all of that being in the brief makes our job so much easier, because we can know that we are on the same page when we start to give that advice in conference. Or if that conversation hasn't been had yet, then understanding that it hasn't been had and this is the first time it's going to be is also very helpful, because it helps to know how to pitch that to the clients and to prepare them appropriately for the next steps.
So looking then at the immediate run-up to a finding of fact hearing, the court needs to consider, but also you as your client's representative need to consider the issue of special measures or participation directions. The court's under a constant duty to ensure that this is actively considered at each and every hearing, and any applications for special measures will need to be made promptly. It's really important that you're able, and indeed counsel is able, to reassure a client that there will be a separate waiting area, that there will be separate entrances, that there will be screens. The worst thing that could happen is for those participation directions not to be present. That does not reassure the client, and it may damage their confidence going into a finding of fact hearing. There are often issues surrounding intermediaries or IDVAs being present at court, two very different things I hasten to add. In my experience, intermediaries are more likely to be present in a public law setting. Lots of reasons as to why that is, but there's nothing to say that intermediaries, and indeed if they are needed, that they should be present at a private law hearing. And it's important that intermediaries are then communicated with, that the necessary reports are completed beforehand, that the ground rules hearing takes place. That may well take place at the same time as a pre-trial review. And also IDVAs, so domestic violence assistance, or people that assist clients at court. At a finding of fact hearing, some judges will allow them to be present, others may not, and may simply say, well, if they are represented, then there's no need for the IDVA to be present. But if the client does want an IDVA to attend at court, that certainly is something that will need to be considered. And this might not be a matter that's immediately your focus if you are representing a client, but the other side might not be represented, and so you'll need to make sure that the court is aware of the need to either have written questions directed or the QLR scheme to essentially kick in. And from memory, that is those are applications made after June last year, in which the QLR then could be appointed to ask questions for the purpose of cross-examination. Those types of things will need to be discussed and thought about carefully at the PTR stage. But there are also practical things that could take place which help assist your client, or indeed the other side, give their best quality of evidence. And that might be something as simple as visiting the courtroom and just seeing the layout of the court. In my experience, and perhaps this was something that was more prevalent because of the coronavirus pandemic and the restrictions, but quite often the finding of fact hearing was the first time that a client would then be in a physical courtroom. It benefits everyone and harms no one, in my view, for the parties to be able to view the courtroom before going in to give their evidence.
One of the other very common problems with fact-finding hearings are interpreters and translators. They're something that is often thought of at the last moment rather than being prepared for in advance. And it can be something that causes the proceedings to go off entirely and causes a lot of delay. I have had numerous experiences where the court hasn't booked the interpreter that they should have done. Either there is an interpreter but they're speaking the wrong language, or there isn't an interpreter at all, and so you spend hours of the first day trying to ring round to find an interpreter to attend at short notice, which of course just raises everybody's anxiety about whether or not the hearing is going to go ahead or whether or not it's going to have to wait to another day. That's a problem which happens frequently, and so it's something to be aware of and prepare for. It's important to make sure initially that the interpreter that you're requesting from the court or as a conference interpreter is the right language. I have had experiences where clients have said, I don't understand what the interpreter is saying, and they don't understand what I'm saying enough either, and so that puts us in an incredibly difficult position to proceed at all. And so making sure that that language is correct from the off is one of the first things that should be raised with the client, to make sure that they understand what's happening in court and they understand the evidence they're giving. An example of this is whether or not a client speaks Urdu or Mirpuri, and those can be languages which are used interchangeably, or the client may have a preference, or they might not understand one, they do the other, and those things are things to make sure the client is clear about from the off, particularly if they have multiple languages but there is a preference. Finding out which is their strongest language is important, because that's the interpreter that they need to give their best evidence. The same applies in respect of statements. The detail, it needs to be important, and making sure that that is in translated properly, and that it's done with the proper wording in that document as well. It needs to be done procedurally right, otherwise that can cause, again, great delays and problems at that fact-finding hearing. There also can be questions to the clients of whether they prefer a male or a female interpreter. Some have a preference, some don't. But if they do, then it's important to find that out and see what you can do to arrange it. In terms of the court interpreters, that is, of course, entirely down to the courts and whether they book them. But my advice would be to ring the court, email the court the week before the fact-finding hearing, just to double check that they've remembered to book interpreters, because there could be so many occasions when they've simply forgotten. And so giving them a polite reminder can make a very big difference. Again, if there can be a possibility of the same interpreter attending, as particularly as the conference interpreter, that can benefit the client massively, because they get familiar with that person and they know that that person is going to be with them throughout the process, and they can be a very different type of support to what counsel can in that situation, because I'm focusing on their case and focusing on the evidence quite a lot of the time, and then we'll have somebody else there that they feel can support them in a different capacity, and so that's important to get right as well.
To hurry through the next set of slides, which essentially is how not to prepare for a finding of fact hearing, but most of these are issues that are simply the other side of the coin when it comes to how to prepare for a fact find. So I don't need to spend too much time, hopefully, on these slides. There are risks when it comes to finding of fact hearings, and those risks must be communicated with clients properly. Even though findings are made or alleged against the other party, as Francesca has alluded to earlier, there is always a risk that the court may well find that there was, for example, a failure to protect, or that one party was also responsible for behaviour that should not have occurred. Ultimately, it isn't a matter for the parties to essentially try and argue that one party's behaviour was worse than the others. That's not what the court's interested in. The court will look at the impact and the risks to the child, and that's something that the Section 7 author and then ultimately the court will need to consider. It's really important that finding of fact hearings don't become tit-for-tat hearings, because that will benefit nobody, and not least the child. Looking at bundles, yeah, so if you are responsible for preparing the bundle, make sure that it is prepared, that there are copies sent to the court for the judge that there are copies sent out for the witness. Of course, that witness copy is sent to the court, so it's placed in the witness box, and any electronic copies as well are sent across. There is an expectation now that all bundles should be searchable and also numbered. Please ensure that that does happen. But that does, of course, mean that some of the older bundles need to be revisited. I appreciate that's something that just causes more work in your offices, but it's something that the court will expect to happen. Certainly, I've had lots of tellings of by judges who have said, "Well, Mr. Javed, I can't search for a particular term, or the index isn't linked to the statement." Frankly, I couldn't link the index to statements. That's beyond my capabilities, but that is what the court expects. That, I think, brings us to the end of our presentation. I appreciate that we are now beyond 5 o'clock, but Francesca and I are both available to take questions, and it would be really good to have questions and hopefully then be able to give you responses as well. I'm going to exit the presentation now.
So I think Lee has let us know that they can't ask questions. There's no functionality for any chat, so I think any questions will need to come by email, but I'm sure that Lee can pass on our email addresses along with the slides if that's needed, and questions can come that way.
Okay, thank you. Apologies, I wasn't aware of that. But if there are any questions, certainly do email them to us, and we'll be happy to respond. But I think that brings us to the end of the presentation then. Francesca, thank you very much for your presenting. And once again, any questions, please do send them our way. I shall end the stream now.